This is a training session for Salam and Company solicitors. Uh, we have a brand name of Salam Immigration, so we would say that this is a Salam Immigration training session. Uh, this is being conducted in Manchester for the staff here, and today is the 30th of October 2015. The today's topic is naturalization, which is a part of the nationality topic. And now I'm going to summarize, correct, and elaborate and uh, make say this training session more useful. This is being recorded and would be available to others as well. Naturalization is something which is for adults only. For those who are not adults or minors, we have. Now I'm going to summarize, correct, and elaborate and uh, make say this training session more useful. This is being recorded and would be available to others as well. Naturalization is something which is for adults only. For those who are not adults or minors, we have registration as British citizens. So naturalization is for those who are over 18 and they decide on their own as opposed to the minors. Uh, the requirements would include 18 years of age, mental capacity, full mental capacity. If you are not able to take your decisions on your own, you can't decide to make an application and become a British national, or because it involves a change of nationality or an additional nationality, which is a big decision. So if someone is not of sound mind, he should not be able to apply for naturalization. Then there are residential requirements or residence requirements as we call them. Then there are good character requirements. If someone is not of good character, he would not be naturalized, he would not be granted a British citizenship. Then someone who applies, these are pretty recent things, should have a good English language proficiency and should also have some sort of knowledge about the culture and life in the UK. So life in the UK test is something you need to pass. For English language, you need to pass a B1 English test. Then there is a requirement of intention to stay in the UK, at least by way of having a principal home or a principal residence in the UK in the future. It doesn't exactly mean that you would remain here, but you should at least have that intention. And at the date of the application, you must demonstrate that you have a principal place of business in the UK where you intend to live for the rest of your life, say at least 6 months in a year. But these are only intentions. They don't say create a problem for your nationality to continue. Once a nationality is granted, it is very difficult and very rare that a nationality is sought to be cancelled. There are situations, but it's very rare and it's very difficult as well. Okay, then the requirement is that you should not have been in breach of the immigration rules. We find the naturalization requirements in Section 6 of the British Nationality Act 1981, and these are elaborated more in Chapter 18 of the Nationality Instructions issued by the Home Office. The Act is quite broad or general in a number of aspects, like a lot of things are left open, like good character is left open. It's not even defined in the Act what is good character. So this is left for the government to form a policy. So the Home Office has produced a policy. They keep on changing it. Like recently they've made changes. So like good character is then explained in the Chapter 18 as Annexure D to the Chapter 18 of the Nationality Instructions. Then we have Annexure B for residence requirements. it has been elaborated there. Some discretion is available there, which is not there in the enactment. So the Home Office has given their policy in Annexure B for residence requirements. Then even for this future uh, plans or future requirements, like your intention to remain in the UK, is also detailed in an annexure Annex F. This future intention requirement is something people do ignore, and even the Home Office also do not ask you any questions or make an issue out of it, but it is a requirement. So we should keep this in view because things are getting tough. The Home Office is not that liberal or lenient anymore. So while uh, making any application, we should see that the person should have, at least on the date of the application, a residence here, whether rented out or he owns it or rented. That's not a problem. Then these requirements are also contained in simple words and simple terms in a guide called Guide AN, which is available on the website. In fact, everything is available on the website. So it's no rocket science. It just requires a lot of reading and obviously understanding. The general public sometimes would read things but would not understand it very correctly. So since you are legal persons, you are in a better position to do so. Read them and then advise the general public. So there's a guide AN, then there's a booklet AN. Booklet AN is just a simple uh, explanation of how to fill in the application form. And the application form that we need to fill in is Form AN. There is a fee with this form which is £1,005, 1005 pounds, which also includes £80 for oath ceremony. Like if someone's application is refused, he's not granted nationality because of any issues, then the £80 for oath ceremony is refunded because there would be no oath ceremony. The balance is the fee, which is a processing fee. There is no refund. So if someone doesn't qualify but makes an application, or he is asked to apply again because at the moment he doesn't qualify but he may qualify at a future date, still the fee is not carried over, it's gone, it's processing at that stage. So you have to make an application again. Now when there is an application, the applicant may be applying as a spouse of a British citizen or on his own. If his wife is not British, it doesn't matter whether he's applying with the consent or sponsorship of his wife or not. But if his wife or her husband, whatever it is, the spouse, is a British citizen, then there is a concession. The concession is in residence requirements and in the indefinite leave to remain requirement. The residence requirement for people who are married to a British citizen is that during the last 12 months he should not have been away from the UK for more than 90 days, and in the 3 years including this last 12 months, in the last 3 years going back from the date of the application, he has not been away from UK for more than 270 days. Now there is, since the requirement is only 3 years, and there is no requirement for waiting for 1 year after the indefinite leave to remain, so they have an edge. The moment you are married to a British citizen, if you have already completed your 3 years, you can immediately file an application for nationality. Like if someone gets indefinite leave to remain today, he or she can file the application today if he's already done 3 years and is married to a British citizen. Another important thing which we need to understand is, it's not that you were married to a British citizen for 3 years. It is you are married to a British citizen on the date of the application. Like if you've married someone only yesterday and become eligible for the reduced residential period of 3 years, that's fine. You can make an application next day or even the same day. There is some discretion, as I said, in the Annex B. They have offered some leeway for people who have more absences. Like the requirement is 270 days in 3 years, but if it is 300 days, they will disregard the 30 days excess absence. Number one. Number two, if someone has more absences but he says, look, I've lived here for more than 3 years, so then there is some more concession. Like if someone has lived here for 4 years, he can have 450 days absences. Again, a little more. And if someone has been here for 5 years, he can have 540 days absences. So these are enhanced absences allowed on the basis of an enhanced residential period. So if someone has resided more, he will get a little more. But if it is more than 5 years, it doesn't matter. That's the end. Now let's discuss everything else as if the applicant is not married to a British citizen. As I said, one of the residential requirements, the first one is that you should have indefinite leave to remain. Now we are talking about someone who is not married to a British citizen. So here there is a waiting time, which is 12 months. You cannot apply for citizenship successfully unless 12 months have elapsed from the date when you get the indefinite leave to remain. And then the requirement for absences or the residence, as you may call it, is that you've resided in the UK for 5 years, counting backwards from the date of the application. And during those 5 years, you have not been away from UK for more than 450 days. Then there is a discretion that if it is 480 days, normally they should ignore the 30 days excess absence. And in addition, if there is a longer residence and there are longer absences, then there is a concession that if someone has lived here for 7 years, he can have up to 730 days absences. Likewise, if someone has 8 years of residence here, he can have 900 days of absences during those 8 years. It's not for the 5 years, it's for the 8 years. You have to take the whole 8 years and match and total the absences, which should not be more than 900. And again, the same 12 months, the last 12 months is important. You should not be away for more than 90 days during the last 12 months. So last 12 months means from the date of the application. So this is mainly the residential requirement. Then we have the good character requirement. Now, good character is, as I said, quite a subjective term. There have been disputes, case law. Recently, a lot of applications are being refused on the basis of the good character requirement. And very trivial things, very minor things are being made an excuse for refusing British citizenship. And a number of applications are being refused. There are judicial reviews in the High Court against such refusals, because there is no right of appeal when an application for citizenship is refused. They have a reconsideration process. You pay £80 and you can apply for reconsideration. There is no time limit for making the reconsideration request, but generally it is expected that you should apply within a reasonable time. Reasonable time would not be just 15 days, it can be 30 days, it can be 2 months, or if you can explain why you have been applying after a very long time. If there is a reasonable explanation, this may appear to be a reasonable period. So if there is an issue, all you can do is make a reconsideration application, which is likely to fail in most of the cases, because if they have applied whatever is their policy, they will stick to their policy. If you claim that no, your policy is not correct, it is not in accordance with the Nationality Act or blah blah blah, they have to follow their policy, because it is the caseworker or a senior caseworker who is bound by the policy of the Home Office. If the policy is unreasonable or maybe even unlawful, unless the policy is changed, the caseworkers have to follow their policy. They can forward the case to some high-ups for consideration of changing the policy and keeping the reconsideration pending till then, but this is rare. So ultimately, they do change their policy, they do make changes. We see changes every now and then, which are in light of whatever they face, whatever is the type of applications they get, and whatever experience they gain from processing the nationality applications. Now, in good character, we can have, say, civil matters and criminal matters. If someone has a county court judgment against him, or some taxes outstanding against him, which show that this person is not a straight person, so then we have a problem. If someone has, say, a county court judgment in which it is apparent that the debt has arisen out of some fraudulent or recklessness of the applicant, then he may not be of a good character and he can be refused on those grounds. Similarly, if someone has been bankrupted, that is a ground for refusing. Now we come to the criminal things. If someone has been convicted, then there is a waiting period. You cannot immediately apply. Like if there is, say, the minimum is a non-custodial sentence. Like if someone is convicted but there is no imprisonment involved, it's only, say, something like a fine. Sometimes there is community service. So in those cases, the waiting period is 3 years. But unfortunately, the waiting period in other convictions where there has been a custodial sentence or an imprisonment, that is to say, then it is quite serious. Like if someone has been sentenced to 4 years or more of imprisonment, then he can never apply for nationality. That is considered as never spent. We have a separate enactment on rehabilitation of offenders, that is an act from 1974 which keeps on seeing amendments. The rehabilitation period in that act is a bit different. I will come to that later on. First, let us see what the waiting periods are. And if someone has been sentenced to more than 12 months but less than 4 years, then the waiting period is 15 years, which is quite substantial. And if someone has an imprisonment of up to 12 months, then he has to wait for 10 years. So these are quite draconian. There is another thing to note, that if someone has a non-custodial sentence like fine or something, as I earlier said, the waiting period is 3 years, but there is a concession which says that if you have only one such non-custodial sentence like fine or anything else, and that has happened more than a year ago, not in the last 12 months. So if it is more than a year ago, then that can also be overlooked. We do have a lot of issues with motoring convictions, because motoring is something quite common. General public, they are all driving, if not every day, quite often. So they do come across speed cameras, they do come across police stopping them if they are not driving properly. Sometimes it's over speeding, sometimes it looks like the person is drunk while driving, or if there is an accident, maybe it is recklessness on the part of the driver who's now the applicant. So they also create issues. Any police fines, like when it's like a fixed penalty notice, like when they catch you for speeding, either the police or a speed camera, they offer you a fixed penalty, and if you settle it by way of fixed penalty and points, there is a mechanism available, then it is not a criminal conviction. So then it is like a civil penalty, it's something settled otherwise. So that doesn't count. So there is no waiting period if you have something like that. But good character doesn't mean that if you are not convicted, then you can never be refused. Say if you do such things every now and then, like even if you have a number of parking tickets, you are habitually not paying parking fees, you're habitually parking wrongly. Say if someone has dozens of parking tickets in, say, the last 12 months, or there is no fixed fee, I'm just no fixed time, I'm just giving an example. So he can still be refused as someone of not good character. Similarly, if someone is caught for speeding again and again, and then it is settled by way of fixed penalty notice, they can still refuse you if it looks like this person is a habitual offender, he has no respect for the law. Uh, when something goes to the court, like the magistrate court, like sometimes you challenge the speeding offense, uh, you say, no, I was not driving at this speed. You go to the magistrate court, mostly you will fail because the camera would be something as evidence which the court would not doubt. If there is a police officer, he would also have uh, a gadget through which he has recorded the speeding. So it's the police officer's evidence in the court. He will come as a witness. If he would say, yes, I have seen him driving fast and I have measured his speed, this is the gadget or device which shows that he was driving more than the limit, then invariably the courts would say, yes, this is sufficient evidence, unless you cross-examine the police officer and try to prove that he is a liar. So, which is quite difficult. And plus, why would a police officer lie? He would not even know who you are. So that's why the courts would take their word as truth. So when the magistrate convicts you for anything, if you get even a fine, the same fine now becomes a criminal conviction. And if it's a criminal conviction, then you have to wait for 3 years. And sometimes there are some serious ones like drink driving or say reckless driving, and you are convicted with even imprisonment at times. So then you have a serious problem. Like uh, any imprisonment would be something entailing a 10 years waiting period. So we need to be very careful. We should obey the law as much as we can. The English requirement, as I said, is simply any English test that you have passed, which is equivalent to B1 level of the European framework. So we know what tests are. There is a guidance on it. If there is any confusion, life in the UK test, there is no confusion. We know what is a life in the UK test. If you pass that, that's fine. Finally, we come to the documentation. Documentation in nationality applications is something which is quite simple. You don't have to provide a number of documents like with the other immigration applications. You have to provide a number of documents. Here, you provide a very few documents. Like if someone is claiming a short residence period on the basis of being married to a British citizen, obviously he should provide a marriage certificate to show that that he is married to a British citizen. Similarly, if someone is in business, he has to provide say something from the HMRC so as to enable the Home Office to check your tax records, like a self-assessment statement or something like that, because they need to see if you're doing a business, are you paying taxes. With salaried people, they don't have to provide anything from HMRC, they only have to disclose their national insurance number in the application form, and that is enough because the taxes are a liability of the employer. the employer has to deduct the taxes and pay it. If he has not done so, then the employer can be held liable and they can recover. So they don't make an issue out of any unpaid taxes on salaries. So that's why they don't want any documentation on that. So for the residential requirements, you have to provide passports covering the residential period, say it's 3 years, 5 years, or whatever it is, say uh, 7 or 8 years. So the passports for all those years, whether it's one passport or more than one, they would normally show all the stamps of being in and out of the UK. But we do have issues with people traveling within Europe. Obviously, most of the people would travel to Europe just for holidays, so there won't be many. But if there is something more than that, then you need to provide alternate evidence because it's not apparent from the passports that you have been in the UK, even if there is no stamp there. Uh, the At the airport they do stamp and put an exit stamp on your passports, but you do not always get a stamp when you re-enter the UK. So we don't know when you after you've left when you came back. So that can be an issue, and we've done cases where in appeals we had to provide a lot of evidence like bank statements for all those years, employer's letter for all those years. We would say yes, he has been on leave only on the following days and he has been attending the office or business throughout this period except for these absences, sometimes something from the university or college where you have been studying, things like that. The bank statements, what I meant was, they would also sometimes show that there are transactions going on, you're issuing checks, you're withdrawing money from the ATMs here in the UK. So that is an evidence that you were in UK. Sometimes there would be ATM transactions, say from Spain. That means you were in Spain on those days, and suddenly after a few days there are ATM transactions in UK. So that shows that you were back. So that can be sometimes an issue. There are no requirements for any educational qualifications. You don't have to provide anything like that. There is no issue with benefits or tax credits. A lot of people would ask, this is a frequently asked question, if I'm taking benefits, would that affect my nationality application? The answer is always no. Once you have your indefinite leave to remain, then that is something which is not a consideration at all for a nationality application. So that's why very few documents are required. Wherever relevant, like if there is say a criminal conviction or a county court judgment, the form would ask you for that. So it's always advisable to not only give the details but also attach copy of any conviction order or sentencing order, just to elaborate exactly when was the date of conviction, what was the date of sentence, and things like that. One thing with the convictions, I would say, although the application date is material, when we say 3 years from the date of the application, you should not have, counting backwards, any convictions. But if at the date of the decision 3 years have elapsed, they will still grant you nationality. So that is a concession. You don't have to say provide a copy of any tenancy agreement or of your residence in the UK to show your future intentions. It's not required. There is a list given at the end of the form AN, which is quite useful for you to understand what documents are required, but it's nothing extraordinary. With the breach of immigration conditions, sorry, the last thing I could see on whatever scribblings I've made for my memory is something that is required, that your stay is part of the residential requirement. So if you meet the residence requirements but part of that is not law. 5 years or whatever period of residence that we have discussed is all lawful residence. It's not unlawful. If someone has been here illegal and somehow he gets in the end indefinite leave to remain, he cannot apply after 12 months saying that I've lived in UK for 20 years and it's been more than a year that I've got my indefinite leave to remain. No, he would not get it unless he completes 5 years or 3 years, whatever it is, of lawful residence. So lawful residence does not only mean that you had a visa all along, but you have been abiding with the conditions of that visa or that leave to remain. Like if a student completes his requirements, but while a student he was working more than what he was allowed to work, or he was working when he was not allowed to work, so that becomes a breach of the immigration rules. Similarly, if someone is not eligible to draw benefits before he was, say, a settled person, before getting indefinite leave to remain, that can be an issue. They would say, oh, you have been breaching the immigration rules. Your leave at that time did say that you are not allowed to have recourse to public funds, but you were having recourse to public funds unlawfully. So you were in breach of the immigration conditions. So if the residence requirement is 5 years, so you need to wait for 5 years if you do, during those 5 years if you have breached the immigration rules. If it's 3 years, then you have to wait for 3 years. All these 3 years you should not have breached. Unless you reach 3 clean years or 5 clean years, you cannot qualify for nationality. Lastly, I would say that there is a facility available for people to go to the town hall, the councils, some of the selected council. They do provide a service where they do a preliminary check of your application, and while doing that they will guide you. They charge you about £60 for their service, and the good thing of that service is that they will look at the original documents and keep copies and return the original documents to you, so that you don't later on have to face loss of documents, or sometimes you urgently need back your documents including your passport. So that is a good thing. With passport, sorry, I wanted to add one thing. If your passport, say if you are a Pakistani, Indian, Chinese, whatever origin you are, if your passport has expired, that is not an issue for a nationality application, because you are applying for British nationality. The passport is there only to show your residential requirements and that you meet the residence requirement, and your identity. Your international identity is your passport. So before you are British, that is your identity. So if you don't have a valid passport or you have an expired passport, it is not an issue. Another thing which I can recall is important is some countries have issues with dual nationality, like we have China and India, and Sri Lanka, some other countries. They say that if you get any other country's nationality, then you will have to either give away the nationality of your own country or surrender the passport. They may give you still an ID card of that country to travel to that country. So that doesn't affect your nationality application. You are still okay to apply and get the British nationality, because the British government doesn't have any issue with dual nationality. You can have any number of nationalities. The British government doesn't care whether your country of origin has any issues with that. This is between you and them. It is between you and China or India or whatever. Like in some countries like Germany, they never allowed it, but recently they started allowing only by application. You have to apply it to them that I need to apply for British citizenship or US citizenship or whatever. So I need your permission. You explain the circumstances. They may allow you. Lastly, I would say that the period of nationality application processing keeps on varying. Generally, it is about 2 months, but sometimes it has gone up to 6, 7, 8 months. Say last year the position was very bad, but now generally it's 2 to 3 months you do get it. But some applications, if they are not very straightforward, if they are not prepared very well, they can take more time. So professionally prepared applications, they always stand a chance of being decided promptly, because the caseworker sees no issues, he's got answers to everything, everything looks quite clear. So he is encouraged to decide that application. They have to give output as well. So they would decide those applications first, which are very straightforward, very well presented, professionally prepared. Then we have, during this processing, we have the passport interview as well. People do approach us and say, I want to apply for a passport. Sometimes they are applying for a nationality, not a passport. So they think passport is the nationality. No. Once you have the nationality, then the next step is to acquire a passport, which is just a formality. You just ask for a document to verify that you have a nationality. So when you are granted citizenship, you have to go for an oath ceremony, which is just a formality. They give you a certificate of naturalization, and then you make an application for a passport, and then they call you for an interview. Because it's your first British passport, they now always call you for an interview. Previously, they would only ask a couple of questions to see you are the same person, there is no identity issues. But now they ask more than that. Sometimes it's a 30 minutes to 45 minutes interview. They ask you dozens of questions, but mainly they are from your previous application form or nationality application form, just to make sure that you are the same person, because there have been identity frauds. So there are a lot of more ifs and buts which I have not covered in this short training summary. So we will deal with the specific issues in more detail, like with criminality and other things. There are a lot of things which have to be big issues at times, so they can be discussed in separate sessions. I hope this session has been useful and you've got useful information on dealing with naturalization cases. Thank you very much.